Chinese New Year, everybody, which is Sunday. And do we have any items that people would like to discuss with us under the public comment section?
We have not received any requests for public comment at this time.
Is there anybody in the audience that would like to say something? No?
I'll go out there and say
Would you like to go out and say something? We have some guests tonight. Hi, ladies.
yeah, I'm not.
Are you here for a class?
Yeah, we're nursing students.
Ah,
Oh, we just had to go to like a community meeting.
So I would encourage if you want them to come up.
And you
or
went to this
get
one?
them
sure.
on
Come
mic
on up
or
and
not.
tell us about it.
What
Tell us
class?
about what you're doing.
Weightlifting or sewing?
No, come on up. So you're on the mic.
Yeah,
No
sure.
way.
Just come on. We don't bite.
I don't have anything else to say really.
Well, we want you to say what you just said into the mic.
No.
Come on. We're really nice.
I could repeat
She's
it for them if
forceful
you'd
that
like.
I was kidding about
That's
the
fine.
taking the numbers and all that.
So
You're
your
supposed to state my name, where I've been, and
first and last name and city
say
of
hi.
residence.
my name is Samantha Castbaum. I'm from Portland, and we are students at OHSU getting our BSN, and we needed to attend a community meeting to learn more about how to work with projects in the community, so we could present them in the future. So,
Wow.
Well, welcome both of you.
thank you.
Well, you need to go to a neighborhood meeting then.
Probably,
Yeah.
probably lots of meetings.
These meetings are less contentious than Portland meetings.
Well, welcome. Thank you so
Thank
much for
you.
coming. And
Yeah.
like I said, you can find out when our neighborhoods meet, and you could come to a neighborhood meeting, which is, while we are part of the community, we are not acting as the community necessarily. So neighborhood meetings are going to be more grassroots and sort of down at the sort of the
Neighborhood
street
level.
level.
Right.
There's grassroots and grass tops.
And grass tops. There you go. I like that. All right.
Well, thank you.
Well, you're going to learn today, hopefully. We're doing our legal training session today, so we're going to talk about the land use planning process and the work that we do here as commissioners.
Great.
All right. Awesome.
Thank you. Thanks for having us.
Sure.
Do you want me to go back now? Or?
Sure. Unless you'd like to stay there.
Do you want to sit right up here next to me? There's an empty seat.
Tom doesn't bite either.
Laura, are you trying to tell me something?
Nope.
My name's still not up here anymore.
Oh.
Just sign in.
We'll chat offline. I'll make a note. I did not know that.
Okay.
Did you?
I'll
Were you
fix it.
able to log on?
No, you can't. His name isn't there to
You
log
can
in.
do
It's
gas.
okay because you don't use it to vote anyway. So
Oh, God.
He might want to see what's going on.
That's okay.
you can just, if you log on as guest, it's the same.
Log on as guest. Tom.
Or are you going to do something up here? Okay.
I'll come around and help while you
Thank
get
you.
started.
Damon's doing it.
All right.
Okay.
You want to introduce the next item? No? Okay. We are meeting today as a planning commission, and it's a work session, so we don't plan on taking any action on anything, but we are all here to update our learning curve, those of us that have them, and learn new things. And we're going to talk about land use procedures and how we can be more efficient in our decision making. And we have our legal counsel here, Miss Carrie Richter, who has prepared a slideshow for us. And she also sent some information to us online. And it's a memo from last year that it's a land use procedures update. So I hope you all had a chance to review that and look at that, because there will be a test.
How come
Thank you,
how come I go over?
Chairman Griff and planning commissioners. I did this presentation for a few of you in 2015 was the last time. January of 2015 was the last time I've done this. And you all have been sitting up there as planning commissioners for a while now. So I know you know most of the basics. And so I'm going to assume that you know the basics. And I'm going to try to teach you something else. But I can't teach you something in addition until we start with the basics. So you've probably seen this slide before. This is the legal on decision making. So you as planning commissioners sit most often as the judge, deciding land use matters, what we call permits, which are conditional use permits, site plan design review, variances, those are all permits. And decisions like zone changes and plan amendments to particular properties, those are sort of you sitting as a judge to determine those matters, and then you also help make policy, which is the concept plans, adoption of zoning regimes for particular areas. Those are policy making decisions that apply to large swaths of area, and you help on that front too. But when you sit as in both of those capacities, your legal parameters are fixed by the items that are on that list. And many of those things sort of set the floor, and then the code kind of sets more rigorous requirements. And so when the more rigorous requirement exists, you have to comply with that one. One of the things I wanted to talk about too is a little bit, but what about the other things? You know, what about the Oregon Health Authority marijuana regulations? You want to operate a marijuana business, you have to go get an Oregon Health Authority authorization license. When someone comes before you to operate a marijuana business in Oregon City with a conditional use, let's say, are you going to ask them whether they have their Oregon Health Authority license? Would that be relevant? And the answer to that question is it depends on what the code criteria say is required in order to get the permit. If the list of conditional use criteria does not include an Oregon Health Authority license, you might be interested to know that. But it is not within our purview. It is within the Oregon Health Authority's purview to make that decision. Floodplain management permit, for example. Water quality permit from DEQ. We have stormwater regulations on the books that have to be satisfied in order to get a building permit in the city. The building code department reviews that. You have to go get often a DEQ clean water permit to do a particular type of mining or a particular type of discharge. DEQ is charged with doing that, and we are charged with evaluating a conditional use permit against a series of criteria. And if those criteria do not include, does this person have a stormwater discharge permit? Does this person have, if it doesn't include that, we can't ask that of these folks. We can do them a service of asking them if they have that, and reminding them that they're going to have to get it. And it may be that you can't get a building permit until you have it. But if it's not within the scope of these of the things that we review, then it's not part of our evaluation that we can deny on.
So what you're really saying is that we are not precluded from asking, although I recall in several staff reports, staff has said that it must meet all applicable state, federal, and regulations, and that's usually been sort of a condition. Mm-hmm. But we can ask the question.
You can ask the question, and I think it is helpful to people as an educational communication at this phase to talk about what else you need. You're going to have to fill this. You're going to have to get a fill permit. What is your status of your fill permit? But we appreciate the fact that the fill permit is not within our purview. It is subject to the Army Corps of Engineers or its Department of State Lands, or I think it's important to educate people. But at the end of the day, this stuff is, if it's not listed as a criteria, it's not something we can make a decision based on it.
But can we add a condition of approval if it's not within, if it's within the code? It's already there as a requirement. But we can't add it as a condition, can we?
Well, if it's in the code, then it's a requirement, and it can be a condition.
But why would we do that? It's already on the record as part of the code.
Because we try to inform people. There are standard conditions that Laura includes in all the in all the permits that say you have to go get a building permit, and you have to conform with the construction standard documents, the diagrams. There is a standard language condition number 1 that just educates people. They have to go do that anyway. But I think it gives them the first step of, this is what I'm going to have to do next.
Okay, but if we don't say that, is still required.
It is still
And
required.
it doesn't mean that the application's not complete.
No, it doesn't.
Okay.
No,
So it's just something to educate if it's already required.
That's correct.
Okay, I got you.
Don't we already presume that Laura and the team has already asked all those and checked off the list of everything that's required under our code?
We're talking about things that are required down the road. We're talking about building permit, you know, how the road is designed and that kind of stuff. How much pavement you have to put in, what the angles are. You know, I mean, all those kinds of building code specification details that often are not known at the land use review phase.
That's the area land use. Okay.
We always like to talk about stormwater requirements.
Right. Well, I mean, and a lot of that stuff we don't know.
Right.
Okay. Any other questions about these sort of legal limitations? Types of land use reviews in Oregon City. Type 1 decision making are the administrative decisions. They are non-decision making. And with no notice, hearing, or appeal. You may remember we amended our code, I don't know, 6 months, a year ago? A year ago?
Yeah.
That put a number of additional items in the type 1 category, hoping to expedite decision making for folks when these were easy to resolve issues. And hopefully that has resulted in a little bit more efficient processing of applications. But that's what the type 1 review, these decisions are non-discretionary. So these are things that are quantifiable and they don't require any exercise of staff discretion or policy making.
But they do require a certain amount of information to be submitted to the administrative staff so they can be reviewed.
That's correct. There is
Okay,
an
what
application.
happens if an applicant says, I don't want to do that? It's called for by administrative staff. No, I'm not going to submit that additional information. At what point are we in a logjam there?
It would have to be denied because these are quantifiable standards. These are the fence has to be 8 feet high. If you don't submit a plan showing the fence being 8 feet high, I can't stamp it as approved.
Do they have right of appeal?
No. No, these are type 1 decisions. There is no notice and there is no right of appeal.
Okay.
So some of the things, like you said, fence height, building height, like they can't build a 5-story building in, because we have a height limit for buildings. Paint colors in a historic district where there's only the palette of like 16 colors. That's the sort of things that.
Well, I don't think building height or paint colors are the
No.
type 1's reviews.
Well,
I think that they're
they end up falling under a lot of other reasons why they don't be type 1, but it's a very specific thing. Your building
quantifiable.
Your building is
Setbacks,
2 feet too
residential
high, too
there
bad.
are residential housing standards that are quantifiable that are just approved.
Right.
Lot coverage, design standards, things like
Yeah.
that, yes. So if you had 10 people look at the same permit, they should have the exact same answer.
Every single time.
But like Damon said, if they wanted to exceed maybe a height limitation, would it then go as a variance application?
Then it's a variance, and then it falls within a type 2 or a type 3 decision.
Mm-hmm.
Type 2 decisions are sort of limited hearing decisions. Type 2 decisions are they're made by staff after giving notice to the neighborhood and giving the neighborhood an opportunity to comment. So a letter goes out that says that the city has received an application for design review. Subdivisions and design review, are those the two that are type 2s?
That is true.
And a notice goes out to the public that says we've received an application for a site plan design review for this particular building design. You have 14 days to comment. And so the public then submits their written comment to Laura. Laura reviews that written comment and issues a decision. And then that decision can be appealed to the Planning Commission for review. And so, actually, you know what? It goes to the City Commission. It doesn't come to the Planning Commission. So it goes straight to the City Commission for a de novo hearing. So you don't see it. So that's another way that we're more efficient with processing land use applications when they are site plan design review, and subdivisions. Then type 3 review is the meat and potatoes of what you all see. These are discretionary reviews for compliance with criteria, notice, public hearing by planning commission or historic review board, and appeal rights to the city commission. I mean, these are the conditional use permits. These are the variances. These are, I can't think of what other types of permits. What other types? Interpretations,
Master plans.
master plans. So those are the type 3 decisions where you make a decision, and if you approve the application, it is final. If you deny the application, it must be appealed to the city commission for review. So if you approve it, you can be the final decision maker. If it gets appealed, though, it goes to the city commission. Type 4 decisions are plan amendments, zoning map amendments that are applied to a particular property. And all three, type 2, 3, and 4, we're talking about quasi-judicial decisions. This is you sitting as a judge. This is unbiased decision maker. This is disclosure of ex parte contacts. This is the 197763 sufficient specificity disclosures. So all of that comes with this type 2, 3, and 4 decision making. Type 4 decision making is plan amendments and zoning map amendments applied to a particular property. And in those cases, we get a planning commission recommendation with the final decision to the city commission. And then then we have this category called legislative decisions, and this is the policy making. One of the things that I tried to tease out a little bit in the memo that you all got is this question between deciding whether something's legislative or quasi-judicial in the plan amendment, zone change, annexation context. We've had a lot of big projects come through the planning commission that are sort of an amalgamation of zoning and annexation, or we've got one right now, or just annexation of a big piece of property. Or historic properties was a fairly good sized piece of property that was a comprehensive plan amendment and zone change. So we get these kind of consolidated reviews, and the question is, are these legislative or quasi-judicial? And it matters because that's the type of procedure that we are governed by when we process the application. It's a legislative decision. There are no restrictions on ex parte contacts. You are intended to be talking with the community about what's in the best interest of the city when you make legislative decisions, when you adopt the Beaver Creek concept plan, when you
Marijuana regulations.
adopt marijuana regulations, all of those kinds of, you're supposed to get out in the community and understand what people's concerns are and draft policy based on those, what you hear. Whereas in quasi-judicial decision making, you are sitting as a judge. So all of the testimony needs to come, it's supposed to come from the public hearing process where folks get to hear all the testimony and they get to respond to the testimony. And that is a critical component of quasi-judicial decision making. And so there are some factors that courts use to decide if something is legislative and quasi-judicial. And they're really difficult to apply, I think. There's three of them. The first one, is the application likely to result in a decision? So take marijuana regulations. Those could or could not result in a decision, right? The Planning Commission could have decided not to adopt any time, place, manner regulations. They could have decided that. So is it likely to result in a decision? Second factor is it subject to criteria? Well, everything we do in the land use context is subject to criteria. I mean, you got the statewide, all that, the list I gave you at the start, those are all criteria. Statewide planning goals are criteria. Transportation planning rule is criteria. I mean, all of that sets out criteria. So I can't think of a time when you wouldn't have criteria that would be applicable to a decision. I suppose with marijuana rules, there were fewer criteria than there are in a master plan review. So I can see that's a different variety of criteria, but that's the second factor. The third factor is the size of the piece. The size of the piece that is affected. If you are affecting lots of properties, it's more likely legislative. If you are affecting one property, it's most likely quasi-judicial. Where it gets dicey is, what if one owner owns 100+ acres? You have one owner, but you have a big piece of land.
With lots of neighbors.
That has planning implications that could be significant.
I think when you talk about that, I think of the development that Salishan became. That was one property owner who owned a whole bunch of pieces of property, but there were multiple layers of requirements ranging from federal requirements to state requirements to county requirements to this, because I don't know, it's not even in a city, it's in the county, so there were no city requirements, and it was massive.
So the risk, if you process a legislative decision quasi-judicially, in other words, it's a policy-making decision, but you go through the 197763 disclosures, excuse me, and you make sure you have no ex parte contacts, and you go through all of that, that is harmless error. So if you assume it's legislative, if you assume it's quasi-judicial, it turns out to be legislative, there is no harm because you give an extra process. Mm-hmm. But if you assume it's legislative and it turns out to be quasi-judicial and you have deprived people of their entitled process, that's a problem.
But isn't all of this ironed out prior to it coming before us? I mean, the application would either be defined as quasi-judicial or legislative, and that would be at the administrative staff responsibility to conduct all that.
Yes.
Because we're sitting up here, we're not going to put an application together for them.
No, you're not.
I don't feel comfortable doing that.
No, you're not going to. But the critical thing the reason why I'm telling you this is because I want you to see that it's not as clean as you think. And I can make a decision about something being quasi-judicial and I could be wrong. And so when in doubt, I always try to err on the side that it's quasi-judicial. So you may say to yourself, gosh, this is 100+ acres and this feels like a lot of fuzzy policy making. I think this is more legislative. And I'd say, well, we're going to give notice like it's quasi-judicial. And we're going to give Measure 56. I mean, in my memo, I talk about Measure 56 notice and Metro notice. And we are going to treat this, DLCD notice, we're going to treat this like it's quasi-judicial, even though it could be legislative.
That's the Department of Land Conservation and Development. That's what DLCD stands for.
So basically, you're going under the old legal maxim of better safe than sorry.
I thought that was Peter's principle.
No, Peter's
I
principle
can't
is
move
how
the
far
slot.
you
Oh,
can
now
move
I
it.
can. Okay, so we've talked a lot about what's in this slide, and I think you understand it. The other thing that I think that the other reason why I bring this up is, and why I think it's important to you, is that we have not, as staff, done a good job, and I don't think that our chairs have done a good job of being really clear about what's going to happen next. And I think we need to be more clear as we try to encourage more participation in the process. We need to be clear that we are, even though we're closing a hearing, we're leaving the record open. When, we bang the gavel and say we're moving on to the next thing, we're saying we close the public hearing, but the record is open.
What does that mean exactly, specifically?
It means that you can submit paper in.
Who can?
Anyone.
Anyone.
Anyone. So we have a public hearing that opens at 7 o'clock on a Monday night, and we open a matter, right? We take a proceeding, we open a proceeding, and then that proceeding ends. That proceeding at the public hearing can open and close, but the public record, the paper that can come in to the file that the planning commission and the city commission can review is still open.
But we usually specify a date that it closes so that, you know, that process ends. Then staff has the opportunity to put all that together and get a report to us in the time that it takes and all that.
Right. No, I know that, but we need to be really specific about what we're doing with the record and what the expectation is. And I think sometimes when our hearings go late and everybody wants to get out of here, we close the public hearing and we're walking out the door. We say, "Oh yeah, but the next hearing will be this day," and we've already sort of adjourned the hearing when we're telling the public that the next hearing will be. And I think as we're getting more complicated applications, we're having applicants seek continuances. As it's not like a person would know that this was the initial hearing, and I would expect that the next 3 planning commission hearings, this will be resolved. You know, these things are dragging on a little bit longer than that.
Because the hearing, the public, the record's open, is there a situation where the commission, after the matter is referred to them by the planning commission, they would see something that the planning commission hadn't seen? They only address what's on the record, do they not? They don't accept new testimony and new findings at the commission level that we haven't seen.
Only in legislative decision making.
Okay.
In all type 2, type 3, not type 2. Type 2 it's de novo, but type 3 and type 4, the meat and potatoes of what you review, the city commission's review is on the record. That means that the city commission doesn't take any more evidence. And that's another, thing we ought to think about when we're talking about educating the public about what is going to happen next. Denise, I think we ought to consider putting in the
spiel.
The little spiel that this is a type 4 hearing. You will not have an opportunity to submit additional testimony before the city commission. So anything you wish to submit into the public record needs to be submitted before the close of the record, before the planning commission.
Gary, can I get a clarification on de novo?
Yeah. De novo means anything can come in.
Thank you.
Means open. Like new. De novo means like new. And when you think about this in terms of policy, you are the quasi-judicial proceedings, you are the fact finder. You're the judge, right? You're the trier of fact. And then the city commission on appeal reviews the record like an appellate court to make sure that all the I's are dotted and the T's are crossed and the interpretations that you made were correct. Interpretations of the code, not to revisit the evidence.
And in fact, they act like that if something came up between the 2 hearings, new evidence, then the city commission would basically remand it back to us, say, you have new things have come up, like the LiDAR maps from, Dogami are finally public or whatever. So then they'd bounce it back to us, not make a new decision over the top of ours, is what they should do.
Well, the code does not say that. And since they are the makers of the regulations, they can make decisions that are different than the regulations. So because the code does not say that the city commission must send it back in order to take new evidence, I'm not sure they would have to, but that would be something that they could consider.
Doesn't that leave the city open to challenge, though? I mean, I know I would. My goodness gracious, if the planning commission hadn't considered this new element that is really going to affect the decision one way or another.
Well, I think it would depend on why this new element wasn't brought into the planning commission proceedings. I mean, as you know, and under the 197763 disclosures, any person at the first hearing is entitled to a continuance. And so it's difficult for me to understand why whatever this new evidence was couldn't be procured during the time period that the record was open. I mean, there would have to be some explanation for that in order to justify reopening the record at the city commission.
Terry,
level.
I'm sitting up here, and sometimes I know when I'm being played, and sometimes I don't. And these people down here, when they got $100 million riding on, they're gonna have a strategy walking through those doors, and that strategy is going to say, what do we have to do to win? And sometimes it's overloading us with minutia, and sometimes it's not. They're holding back and see, well, can we get away with it? And we'll find out, you know. And they're playing a little bit of poker with us. I understand that. I hope my colleagues do. We've got a lot of smart people up here, but this has become because of the emphasis on the process and not the elements of planning, but the process. I mean, my goodness gracious, we're sitting up here and we're just sitting ducks. We're not attorneys, and we have to read this.
Right. No, and I appreciate that. I mean, there is, you know, a lot. You think about, you know, Oregon land use planning's been around for many years, but there are still a lot of things we don't know the answers to. And I can tell you what the risk is, but I can't make it a non-discretionary type 1 decision for you. I can't give you that kind of quantifiable certainty.
That's what deliberation is all about.
Well, and interpretation.
Yeah.
Okay, so moving quickly, you know the quasi-judicial hearing disclosures. I don't need to tell you them. Staff report is to be prepared 7 days in advance and be available. You have a right to an impartial tribunal in quasi-judicial decisions. So I want to talk a little bit about what that means. Decisions have to be based on the testimony and evidence that is in the record. This requires that you disclose ex parte contacts on the record, giving the public an opportunity to question the decision maker further. And the critical point I want to make about ex parte contacts is that all of them are supposed to be disclosed at the beginning of the hearing. And this includes, I went to a neighborhood meeting and it was discussed. This includes, I've driven by. This includes, I was at a Willamette Falls event and I overheard 2 people talking about it. This includes, you ought to err on the side of as many as you can think of, because I, in my own experience, have heard deliberations where, so deliberation is way at the end. After all the testimony is presented, the public record is closed, deliberations are going on, and somebody says, you know, I heard Joe West speak about the cost of utility extensions, and I can tell you they are ridiculously high. And that is an ex parte contact that should have been disclosed at the beginning. And so we have to be really careful when we learn things outside the public meeting and we don't disclose them. And let's say we're at the deliberation and you remember that you had an ex parte contact, or you didn't realize how important steep slope stability was when the application started, but you have, recalled some reading that you did a couple of years ago in National Geographic about slope stability. We have to disclose that before you make a decision. We have to disclose it at the beginning of that hearing. And
or as soon as you realize that it's relevant.
Right, but what I hear sometimes is that this stuff comes out not somebody is explaining their position and they don't say, I am disclosing this as an ex parte contact. You know, I am disclosing that, you know, I know more about whatever because of something that happened that I learned outside of the hearing. And I appreciate that many of you are land use planners and have particular expertise because of your building or utility or land use planning expertise. That's general knowledge. And you don't have to disclose every time that I used to be a land use planner, you know, or I have particular expertise in historic preservation. You don't have to disclose that. But if it has some specific bearing on an application that's before you and the criteria that you are going to apply, and that data is evidence that you are putting some value on, you have to disclose it. And disclosing it, you know, the sky will open and the clouds will clear and you are clear of any problems, you know. I mean, it's not, you don't have to feel bad. You are members of a community, and of course things are going to come up, and of course you're going to hear people's opinions. That is to be expected. But just write them down and put them on the record.
So, my bachelor's degree is earth science, which is geology. Should I be saying that?
No. No.
Because I know things from, you know, but
No, because
I can't put a point of where I heard this fact, but I remember it from my classwork, you know, I mean.
No. No.
Okay.
But, you know, for example, you know, I just read on the Weather Channel that Portland was voted has the worst city wet weather this year. Of all the places in the United States, Portland has the worst city weather.
Good.
And so, you know, would I look at a steep slope? You know, if I were a planning commissioner, would I look at a steep slope and not think about snow removal? I probably would think about snow removal. You know, because Portland's got the worst winter, and I read all about the statistics today about, you know, how many days of bad weather, of freezing weather, and all this stuff. And, you know, so would I need to disclose that? Probably, because I have some opinions about snow removal. Because I read that. You're going to have to use your own judgment. I mean, at the end of the day, nobody's really going to know what stories you read. You know, but I encourage you, you know, when you think about your deliberations, to try to disclose things before you disclose a fact that is an ex parte
So it just
contact.
boils down to a recent potential influence that you have on
Yeah.
the case.
Which would end up in a bias towards the
To
Well,
a decision.
failure
To a
to
decision.
disclose an ex parte contact, not bias. Bias is a different thing.
Oh, okay, all right.
Bias is you are incapable of making a decision because of your personal views. You are incapable of putting aside your personal views in order to make a decision based on the criteria. Because you are...
Not professional views, personal views.
It could be professional views too. I mean, it goes to this whole question of how are you so connected to this? I mean, and that goes to conflicts of interest. You have a financial, I mean, usually the professional component of this is a conflict of interest issue where you stand to gain financially by an outcome. And in that case, you absolutely have to recuse yourself. If you have an actual conflict of interest, you cannot participate. If you or a family member stands to gain financially from an outcome, you cannot participate.
Gain or lose.
Correct.
So I have a question about that. Ex parte.
Yeah.
Let's say, like last time, Paul recused himself or left because I can't even remember the reason. Kids were employed. Okay. Could he have come out, or could one of us come out and testify to something we feel about to the rest of our planning commissioners, and would that be considered ex parte because they know us? You follow what I'm asking?
No.
Let's say...
No, I follow what you're asking, and yes, you certainly can. You can always choose not to be a decision maker and come out and testify as an individual who's interested.
Okay.
I think Paul submitted testimony.
Mhm.
Oh, I didn't know that. I
Yeah, that
guess I
was
didn't
that
see that.
one
Okay.
you said that
Oh, that was
you-
that big thick one. Okay. All right. Yeah, I've been wondering about that for a while because ex parte, obviously, let's say I come out there where you're sitting, they all know me, and would somebody say, well, you already know him and it's not fair, that's ex
Just
parte.
because we know you doesn't mean it's ex
Exactly.
parte. If we knew you and talked about it,
Yeah.
then it's ex parte.
And outside of the public meeting. But if you come and testify, you're in the public meeting, which is appropriate for the discussion about the topic.
Okay. Good.
So, and you are always welcome to testify as an individual because you are members of this community and you are expected to have opinions, but not when you are sitting in the role of a quasi judicial decision maker in these type 3 and type 4 decisions.
So if you're going to come out there, you have to completely recuse yourself up here. Sorry,
Have
go
it
ahead.
both ways. I mean, there's no such thing as that. You're either there or you're here.
I've been all over the place.
No, you can't do that either.
I've seen it happen before.
When you're bipolar, it
Yeah.
happens.
I have.
Thank you.
All right, so moving right along. I haven't figured out whether up or down moves this the right way. So,
Just clicking it.
One of them.
no, wrong way. Okay. So here are the public hearing procedures. You all know what these are. This is what we do all the time. One of the things that we talked about how at the initial hearing, anybody can request a continuance and they're entitled to it. And what happens after that? What happens at the second and the third and the fourth hearing in terms of right to a continuance? The way it works is that if at the second hearing a party submits new evidence, evidence is facts, new traffic study, new flow rates, new evidence, then any party can request an opportunity to respond. That opportunity to respond can take two forms. It could take the continuance form, which is, okay, we're going to give you to the next hearing, but we are going to only take evidence at the third hearing that responds to the evidence that was presented at the second hearing. We're not going to take new evidence that doesn't respond to the things that were presented at the second hearing, because if we did that, we would never see an end, right? It would be a continuous
Including
submittal of new evidence.
including testimony?
We'll take testimony about anything that's already in the record. We won't take new evidence. The critical component here is that we're narrowing the topics
To get to a decision.
to get to a decision. And so the second way you could do that is you can leave the record open for a period of time and allow written evidence to come in on a schedule. And we call that this 777. I don't recall
We've done it.
that we've done it.
About a year ago.
Yeah.
I mean, but we don't do it regularly.
No. But we did it. Yeah.
Once a year, once every other year.
So the way the 777 works is after the hearing ends, the public record's left open for 7 days to allow additional evidence related to anything. Then there's 7 more days before, at that first 7 days, the record closes to new evidence about anything. Then the second 7 days, people can submit written testimony that responds to the evidence that's already in the record. And then the last 7 days, so we're at a 21-day total at this point, the last 7 days, the applicant is given an opportunity for final written argument. So the record closes, public record closes to new evidence at the 14 days. That last 7 days is for final written argument on argument. Argument is distinguished from evidence. Evidence is new facts. Argument is what a lawyer tells you it all means. What's interesting to me about all of this is that 197.763.6E says that unless waived by an applicant, they are entitled to final written argument before the deliberation if they request it, it says unless waived. In other words, every applicant ought to get this 7 days unless waived. And every hearing I've ever been at, the only people who ever take advantage of this are lawyers who want to have that final opportunity to wrap it up. Yeah.
Just before we go on, so the statute that she's citing, 197, that's in the Oregon revised statutes, the laws that govern the state of Oregon. It's a big old, several big volumes.
I keep forgetting that
many volumes of. Matter of fact, don't you have one of them right there?
I have both of them.
Yeah, well,
Is
that's
this
part of
being-
it.
Is this being on television for people at home
Yes.
too? So it's good explanation for
Yes.
those at home.
So, ORS, Oregon Revised Statute, or if she says OAR, Oregon Administrative Rule. Am I missing any of the initials?
I think that's it.
Elemental.
There's many.
LCDs.
So our
We said that one.
Oregon City one is bigger than the state one?
Yeah.
No, the state one is many volumes. Oregon
No,
Revised
this is only
Statutes
2 volumes.
Yeah.
But the land use parts of these
Is 2 volumes.
are 3 chapters of these
Of
2
the
volumes.
2 volumes, yeah.
And Laura, I think when last time I remember us doing it, we didn't do 777. We just did 7 and 7 because there was somebody had submitted, I think, their own traffic study, and because they'd like pulled the data off of our website of all the little traffic counters and like created their own traffic study or something. I can't remember what it was, but
We allowed 7 days to respond to that new traffic data.
Right, yeah.
And then
So-
7 days for final written argument.
right, yeah.
So 7,
It
7,
was
7.
one of the subdivisions. I remember that was what it's about.
Might have been
Seven's
one of the
like a
Park
jackpot.
Place, is what I recall.
We hit the jackpot, yeah.
I know it's kind of highly unlikely, but you keep referring to the applicant. It could be the opponent too, the public. They could respond to they could enter into the record new findings or new testimony as long as it was written.
No. So we have the initial hearing, it gets continued. We go to the second hearing, it's still de novo, right? It's still free, open, anything goes. So I come to the second hearing, whether I'm an applicant or I'm an opponent, I submit a new traffic study. Whether or not I've created it from a website or I've hired a traffic consultant or whatever. It could be the applicant or the opponent. Either way, the other side or another person, it doesn't even have to be the other side. If I'm an opponent and I submit a new traffic study, another opponent could want an opportunity to comment on my traffic study. That opponent can also get up and say, I want an opportunity to respond to that new evidence. So the Planning Commission has a choice. Continue it to the next hearing and limit that next hearing in terms of evidence to responding to my traffic study. And then all the people can come in at the continued third hearing and talk about my traffic study. Or do this some version of this 777, which allows for written testimony to come in. So it's the same, it's almost like a continuance, which is oral. This is just in writing.
Well, are we to understand then that given the public testimony and the written record, that once that's entered into the record for our consideration, are we to consider the application to be complete? Or is it just a component of the application?
Completeness is a separate question.
It's only information before us.
It's a staff thing.
Okay, I don't think you're using the term completeness in the way we use it as a legal term of art. I think you're meaning, are all the criteria satisfied? And I think that's for you to decide. By the time the record closes, theoretically, you ought to have all the evidence you need to find in favor or deny an application based on the evidence you get. If you don't have the evidence, you can't approve it.
Are you using the word evidence as in the same way you use findings?
No.
No.
Evidence are facts.
Okay.
Findings are the analysis of the law with the facts.
For instance, we had a case that Denise was rather hot on, and the rest of us kind of overruled her, about one of the applications came in without a landscape plan. And staff said, will not issue a building permit until an accepted landscape plan has been submitted or something like that. And Denise was like, I want to see it. I don't want to make a decision until I know what they're doing with their plantings. And the rest of us kind of overruled you and said, well, staff's going to make their decision, and but that would have been an opportunity for us to say, yes, we don't have this information from us. We can't make a decision to the affirmative, so we're going to deny it or continue it. And
that would have been I was thinking of another one where staff had asked the applicant to submit something. They wanted it moved on without it. The staff said, okay, it's your risk. And we didn't agree with, we agreed with staff and said, sorry, we don't, we need this. And you can either submit it or we'll deny, like you said, we'll deny it.
And from a LUBA standpoint, when it comes to evidence like that, the question is compliance feasible and likely to occur? For example, we don't require detailed utility plans about I don't think design. I could be wrong about that at the land use phase. Rather, our Public Works Department reviews what the utility proposal is and says, based on what we see, it is reasonable. A reasonable engineer could say that it is feasible to design a storm system that will comply with our drainage standards and will meet the code. And I think that with a landscape plan, that is kind of the same thing. Particularly in some areas, we don't have criteria. There's a requirement to submit a landscape plan, but we don't have criteria about what you have to plant. And if the criteria about what you have to plant is 5 trees that are this tall, that are this dBi, which means their width at eye level, then, or diameter at eye level, excuse me, then, circumference, isn't it? Then it can't be approved. Well, you don't need to see a landscape plan. Staff can look at a landscape plan and tell you, based on that quantifiable evidence, whether or not the standard is met.
I thought we did have criterion standards about what the landscape plan has to be, and we have a list of plantings that are recommended, and we have all of that.
We do. So if there is a condition for something, when staff does completeness, we can delay compliance to later if it has clear and objective standards, if they're not discretionary. If we have criteria that says you have to have trees every so many feet and they have to be this species and this size, we can check that, and 10 people could check it with the same answer. Again, this non-discretionary thing. So that could be a condition of approval, and we could say with certainty it is possible and feasible for an applicant to plant those 10 trees. So we wouldn't need the Planning Commission to look at that particular piece on the application because it's not really all that relevant to what you're looking at. You know that they can comply given that condition of approval.
See, and I'm glad you brought that up because I find that very frustrating. If they were required to submit it and we condition everything to put it off till later, while part of me wants to say, yes, I believe to a certain degree that they can do this, and I think that's why I wanted to see the landscape plan, because I did not feel confident that we were going to get the quality and level that we should have, and they should have, in my opinion, again, it was just my opinion only, that they should have submitted it along with their application, which they should have. To put it off to, so see, I'm in a quandary. If they're required to have it as part of their application and they don't submit it, why are we putting it off till later, saying that they can do it later when we told them the criteria and the stat and the information says you need to do it now? That's what I have a hard time with that.
Why should the application be considered by this body as being complete when it doesn't include that, which is required?
So if I can grab this one. So there's 2 things going on. So we're talking about landscaping plan. If if
Well, let's
the
say it's
application
anything.
was for a variance on height and they want to go taller and the landscape plan does matter, you maybe want a bigger tree or more trees or something like that. I mean, then obviously we wouldn't do a condition of approval. I don't think that on the planning division level we do that many conditions of approval. There are things that you do have to do conditions of approval that you can't really determine compliance with immediately. Things like tree mitigation, sometimes the trees change, and so you'll always see that as a condition of approval at the end because things shift around a little bit during review. So for the most part, I think the planning division is very, very good about making sure that things are complete. There's two things. One is that the applicant can tell us that the application is complete in their eyes and to move forward, so they can force us to, and we can't do anything about that. But the other,
Whoa. How can they tell us that it's complete?
they in our code, they can. We issue a letter of incompleteness. There is an opportunity for the applicant to say, "I think it's good enough. You need to process it." There is obviously
Which would
risk
start the
because
clock.
we need to, it's
That's
the
actually
burden is on
provided in
them.
state law.
It's,
See,
so
I
it's
think
state
that's
law.
bogus.
But it is-
state law or not.
But it's required.
Yep.
The other thing is planning division staff, as professional staff members, if they see that there's something that could be a condition of approval later, then, if you've gone through completeness 4 or 5 times, the one thing that you guys don't see is how hard it is to get a complete application and how many
don't we
times,
know?
especially in the last 2 years, that
We know about that.
we deem things complete over and over and over. And if it's just missing one tiny little thing, we're not going to deem it incomplete. If it's, clear and objective standard, because we issue an incompleteness letter, we mail it to the applicant, email it to the applicant, they come up with the new plan, turn it back in, we have 30 more days to review it for completeness. I mean,
So there's also an adequacy issue too. They can fill out the, whatever criteria they're addressing, but if they do a lousy job of addressing it, or if they just, write the Hail Mary or something underneath it without addressing it at all, they've addressed it, but they haven't really talked about the criteria, or it's conclusory, or it's
My favorite
So-
is
so-
see such and such
right,
attached.
or see such and such attached, or it meets the criteria because it meets the criteria,
In
or
my-
whatever.
yes,
And you
in-
get that a lot. I know you do.
that is by far, I think,
And-
really
and
what
it
we're
frustrates
talking
us,
about.
yeah.
There's text that's responding to a
Completeness
criteria, and
versus
we just don't
adequacy.
like what it says. We just
Yeah.
don't agree with it, or it's not enough for our level of adequacy.
Well, then
But
you
it's
would-
there.
You would then tell the planning commission that this does not meet our standard.
This would appear in the staff report.
Yeah, so you get a condition of approval to say that we need this, or if you can't demonstrate that is feasible and likely to occur,
Or just say no.
then you say no. I mean, that's so, our conditions of approval, it is challenging though, because that happens all the time.
Yeah, I think the one that
Live in the dream.
Denise was so adamant about, it was like the third one we'd had recent, and we had like 45 exceptions, and it was like the third or fourth with 45 exceptions, and the drawing looked like they'd taken butcher paper and a ruler and drawn and it was just like, no, we're done with this now.
Yeah, I mean, a
but
good
it was an
application-
11:30 at night kind of thing, and it's like,
A good application shouldn't have so many conditions of approval.
yeah.
When I
Well,
see a lot of
theoretically.
when I see a lot of conditions of approval, I get really worried
Yeah, those become
about
flags.
about how, first of all, how good the application was in the first place, and how easy it is for us to be able to comply,
Well, what I
or
was
for
telling
the
you-
applicant to be able to comply with the.
I agree with you. What I was telling Laura, what my
Okay.
frustration is that we get an application, and I'm reviewing the application before I read their staff report, and I'm just looking at it going, really? Sometimes I just go,
Yeah, there's two different
it's like,
worlds.
how did they even get this submitted? It's horrible. I can't figure out what it is you want or what you're trying to do. So I don't read your report first. I read to see what they're saying so I can get a tenor of what they're trying to say or what they're trying to do. And half the time, I will say 3/4 of the time, I'm just like, okay, I don't even know what it is you want because I can't understand what they're trying to get at. And it's just entirely frustrating.
I rely
and I
on
know
the
it's.
staff
I mean,
to
I've been there, so I
help me
know.
through
I
that.
know what they go through. And trying to convince somebody, look, we are trying to help you by telling you what it is you need to submit. And if you don't want to submit that, then we're kind of not left with any clear choices. We don't have good choices.
We got to get over this stuff. That we're we're not satisfied. I mean, we're doing this for the public, and it's not fair to the public. They're getting shortchanged if this stuff isn't complete. We're being asked to approve incomplete plans, and we're a planning commission, for crying out loud.
Well, I don't think that they are incomplete, though, right? I mean, they are complete. We just don't
No,
like
I'm-
what.
if we don't have a complete record, what are we taking action on?
Well, I
If
think
we're-
we've had complete. I think we've been okay that way.
You remember,
It's
you
rather
remember-
short.
I'm not going to go into super detail, but you remember the application we had on South End Road?
Which, oh, you mean the church?
Oh, yeah,
No, not that's not on South End Road, that's on Warner
I'm
Pier.
sorry, bro.
And
South,
with the care facility on Amanda and South
Oh,
End?
yes.
Yeah, okay.
Mhm.
Yeah.
And we gave them every opportunity to get stuff in. I mean, I literally
Right.
was about ready to lose my mind on that application.
Yeah.
And we all kind of lost our minds
But it
on
came
it.
out all right.
Well, I mean, and I think that the only way to get around this is for Laura and her staff to continue to try to educate folks on what will be successful.
Sometimes they don't want to be
And-
educated.
No, I know that, but we don't have that. This is, I mean, the best we can do.
Well, and the other side of it is, like you said, one of the things we do is set policy, and as long as we're consistent with where we have, like, we don't like you cutting down trees, we don't like short setbacks. If we're consistent in that pressure, then that gives Laura the ability to say, if you're, and look at these last 3 meetings, do you really want to sit through that, or you want to just move your building back 2 feet?
Yeah, and just to be clear, we never guess at what you guys are going to vote on things either.
No.
But,
I mean, but that's
Right.
not our job to make clear that there's going to be, that this is a pushback area. And
yeah, and just because we've not filled you in with some of the administrative stuff we've been doing, but over the last year we have spent a lot of time thinking about our process and how to set people up for success so they understand the process, both the public and applicants. And we've revised the pre-app process quite a bit. We also give applicants templates when they apply. So at the pre-app, we say, here's your pre-app notes. These are the things where we see errors in your application and so forth. And we give them a whole separate Word document that is all the applicable sections of our code, and then a space that says applicant's response, so that they know every single section they need to respond to. Before, we were just saying reply to chapter 1762, which has a ton of subsections, and they would hit some of them but not all the right of them. And so we've been trying to make strides at making sure our letters of incompleteness are really thorough, to say, here's what's incomplete, and then, by the way, if we see some answers that don't look right, here's a note that says you might want to think about changing this. But and I think they've gotten better. We were at three rounds was the norm a while ago of incompleteness. It was just really challenging and takes a long time. I think it's a lot of frustration for everyone involved.
Applicant gets frustrated too.
Yeah, applicant, everybody.
Yeah.
Well, with each decision we make, we in essence set a precedent, do we not?
I think that there is as a result of the same people making decisions for a long period of time, a unwritten policy about how you all deal with things. But that is not the same thing as judicial precedent, like the Land Use Board of Appeals. Because every factual situation is different. You're never going to have a case where you're going to have exactly the same facts, exactly the same baseline standards. And in fact, an interpretation of a particular criteria might be different depending on the facts. Generally, yes, I think it's true to say that there is some precedent because you are the same 6 members who have been here for a while, and you all bring a certain perspective that will not change. So yes, there is that, but it's not, you're not bound to it.
Yeah, in fact, I recall one of the land user, one of the applicants in general, tried to make that argument to us that, and in the last 3 applications, you approved this thing, and so therefore we expect you to approve it for us too. And we went, no. So,
Because
I
the
mean,
facts are different.
yeah. Well,
Okay, all right.
so, yeah, that's
One other question. We had a application for, applications for annexation come before us. And from my point of view, I look at it from the standpoint of we're only considering the application for the annexation. Well, people in the audience, and it's natural, want to know what's going to happen on the property, how big a development's going to be. I want to see it, and this and that. And I understand that, it's natural. But when we require that kind of information to come before us, either by plans or testimony, isn't that putting the cart before the horse? Isn't that amending the application when we consider that or require it to be that information be brought before us as part of the annexation?
I don't want to talk about any specific annexation.
No,
because
I'm not.
there
I'm
are
just talking about
some that
annexation
are
in general.
That are pending. I'll tell you what, the challenge with annexation in the city is that the criteria are factors.
Or what?
Factors. Planning Commission, the decision maker shall consider the following factors when deciding whether to annex. A factor is not a criteria. A factor is a very discretionary term that can be weighted in many different ways and can be interpreted in many different ways. And so your job as a decision maker gets more difficult because of the highly discretionary nature of the annexation criteria itself. And I don't know this, but I think that the reason why it was so discretionary was because in the old days there was a vote. So it was a politicized decision. It was politicized at your level, and then it was decided by the political body. We've taken that voting component out. So, but we didn't revisit the factors language. And should we revisit them? I kind of think the answer is yes.
I would say based on what the appeal happened.
But there's the Oregon Revised Statutes and Metro Code that speak specifically to public facilities and the presence and absence of those, and whether or not you can annex based on the adequacy of those facilities, right?
Yeah, I mean there are.
So I think that's pretty. I mean that's really the.
I'm not sure that those provisions are much less discretionary, but again, I don't want to get down into the weeds about any particular application.
No, I won't. But I mean that's because I do annexations, and that's the compass that I use as far as whether or not we can approve them.
But it all kind of comes down to what you have in red here. Make sure that when we've made our decision, that it's clear what we considered and what we didn't, and what we could and couldn't. Like, don't let them build that subdivision. I love that grove of trees. I grew up playing in it for all my life. Too bad you don't own the property. You don't get to make. I don't. I want
to talk about that. Let's scroll through really quickly. I can't.
I can move it if you want.
No, but now I'm going backwards. Okay. Public meetings, you guys know all this, and public records. Any writing, data storage, or other record is a public record, which means it can be disclosed as at a public records request. You all know that. Public meeting is any time you've got a quorum of planning commissioners in a room together, or on the phone, or by computer, deliberating to a decision. If 4 of you are talking about where to get drinks on Friday night, you're not deliberating toward a decision, not a public meeting.
We're deliberating about a decision, but it's not public.
Well, it's to a decision that is before the planning commission in a quasi-judicial capacity. So that's where you get into trouble with public meetings laws, and the cases that come up related to this are usually email related. Mm-hmm. And the critical component about this whole email thing is that staff can, if one of you emails Laura and tells Laura your feelings about something, and Laura distributes that to the group, if any of you respond with everybody attached, that could be a public
It's
meeting.
become a conversation.
Because it's a conversation, theoretically deliberating toward a decision. If you email Laura and say, what time's the hearing? And Laura emails the group and says, the hearing's at 7 o'clock. And Denise says, I'm bringing cupcakes. And, that is not deliberating towards a decision. That is not related to the application at hand. But
It's a cupcake application.
well, but my point is, if you read the staff report and you have questions, you need to email them directly to Laura and not copy the group.
And that's why you'll see every time we email, everything is blind copied, so you can't reply all. And then also related to that, if you ever have any questions about any application or concern or something, please just call the planner and let him know so we have adequate time to be prepared with a response by the time we get to the hearing.
We're not
we
supposed to
really
ambush
appreciate
you?
Well, I think
can,
that's one of those efficiency things.
And it's
The better
professional
prepared,
courtesy.
the better prepared you are. The more questions you ask of staff in advance, the better prepared staff is. And again, we're able to funnel the issues. And the whole idea at the end of the day is to funnel the issues to give you the information you need to make a decision that you're comfortable with. And we want to do that as quickly and expeditiously as possible for everybody. So, we encourage you to send questions just so we know and we can get you the answers, because there is nothing more frustrated to me than to go to a hearing and not know what's going to happen. Because I can't be ready. I can't respond in a complete way when I don't know what the questions are going to be.
Right.
And I think Laura feels the same way.
Yeah, we want
Question
to be
for
here
you.
to help you.
Question for you. You jumped to the public records public meeting, but Bob had asked a question, and I wanted to ask kind of an explanatory thing about it. If you're having a meeting on whether annexation or whatever, if some people want to give public testimony in it, and to them, annexation means all these other kinds of things. Slides, you name it, this, that, or whatever. Maybe they don't like the property look or something, but we have to listen to that and accept that, don't we? Because they're here to testify about something they feel strongly about an annexation.
What do you mean accept it?
Well, somebody comes up to testify. We're listening to it. We're hearing it, so that's accepting it to me if you're listening.
Okay, so folks come up to testify, and we encourage, when Denise reads the thing, I think she says that the criteria we encourage testimony that relates to the criteria. We are making a decision based on the applicable approval criteria, and so testimony ought to relate to the criteria. So the best example is a church that I can think of. Conditional use permit for a church that we evaluate impacts to the neighborhood and all that kind of stuff. We get parishioners coming in and talking about what a good church it is, about what good works the church does. That is irrelevant to the criteria. It's up to the planning commission to determine whether they want to cut people off who are saying things that are irrelevant to the criteria, or if they just want to listen to it, take the testimony into the record, and then decide whether or not it relates to, if it's relevant to the criteria.
Now
So it's one thing to hear it. It's
Right.
another thing to use
Weigh
it as a decision-making factor.
Where I was going with that was that those are personal. Like, we don't like the church there, or this or that. But if somebody wants to talk about maybe landslides near that church, or they want to talk about traffic near that church, that is something that we should take into consideration, right? Because it has to do with that area.
To do with the
Let's
criteria.
let's go forward. Let's go
Sorry.
forward with my last slide. Okay, so the deliberation and the decision, right? You've taken in all this testimony, some of it relevant, some of it not relevant, to the criteria. And so the starting place for me always is what are the criteria? What am I asked to decide here? What are my measuring sticks that I have to use to make a decision? And so what strikes me about some of the public testimony we get is that it isn't attached to any measuring stick. And the question that I want to ask folks when they testify, they only have 3 minutes. I appreciate it's a short period of time. They're often nervous. But the question I always want to ask them is, what is the criteria that your testimony relates to? I am taking notes here. I want to attach your testimony to a criteria. What is that criteria exactly? Because you can't vote in their favor if there isn't a criteria in which to find for them. You understand what I'm saying?
I believe I do.
So if the criteria is whether this conditional use will adversely affect the neighborhood. If I come in and testify that this use is a high traffic generator and this is a residential neighborhood, that particular use may not be appropriate for this local street, small resident, R10 zone neighborhood. So that would be testimony that might be relevant to adverse impact to surrounding neighborhood. But I don't trust this particular user because of some personal factor about them. This person isn't trustworthy. That isn't go to what our job is planning. Our job is making sure that all the uses can work together. Right? The personal views, whether or not a use is a good idea from a business standpoint,
Property
whether
values.
or not the developer is a sophisticated guy or gal, all of those things are not relevant.
Or they come up and tell us, oh, I really like it, or I really don't like it. And I keep telling community members that we don't have the approval criteria that's yes or no, based on whether you like it or not. So you may not like it, but if it meets the criteria and standards, we are bound to make as finding of approval, findings that lead towards approval. If they do not meet that, then we cannot make those findings and we would recommend denial. So what I still have a hard time getting across to people that I get asked questions about, well, what is it, what can I say at the hearing, or what can I do at the hearing? I say, first of all, don't tell me whether you like it or not. Look at the criteria and tailor your testimony towards something that I can use if I find that fact relevant and I can use it as a decision-making portion. If you tell me you like it, yeah, fine. I may not like it either, but that's not part of our criterion standards. And that people find it very difficult to understand that, because they will do things like, I have a petition with 550 people on here who say they don't want this. Well, yeah, that's great, but that doesn't help me make a decision because I don't know why you don't like it and how does that meet the criteria. So I tell people, don't bring us a petition. That's not going to help us. Yeah. Tell me A, B, C, or D, or you pick one of these standards. If you don't see how it meets it, tell me that.
People like to talk about their property values being
Yes,
diminished.
that was the one I hate the most.
That's another
it's like,
one
my property values are going to go down.
Yeah.
Well, how do I know? I'm not an appraiser.
Right.
You can't justify that to me. That's your perception, but that's not a reality in fact.
Is the criteria, Laura, on let's say annexations again, since that came up, is that always the same? Is it based on how big a property, how small a property, things like that? But is the criteria list in the city's
There isn't
standards?
any criteria. She just said it's based on factors, which
And,
are not
that's what I was
criteria.
wondering, because she also brought up criteria.
That's a
It
different
has to meet, if
application.
somebody wants to come up and testify, it should meet criteria. And that's what I'm wondering. Is there specific criteria for annexations that we need to follow?
There
Factors.
are criteria and there are factors.
Okay.
There are both.
They're listed in the
And
municipal
yes,
code.
they're the same regardless of the size of the application.
1 acre or 100 acres, it's the same.
So we need to have a sheet with one side factors, one side criteria. Okay, met this one, didn't meet that one.
Are we using the word criteria like standard
That's what I was wondering.
or category?
I guess, I mean, those words have legal meaning, and then they have sort of layperson meaning, and I think the layperson meaning is that those all mean the same thing. I think from a legal standpoint, they mean a little bit different, but I think for purposes of what you're doing, it doesn't matter. The question is, what is the measuring stick? What is it Metro Code provision? Is it city code provision? Is it comprehensive plan provision? What is the measuring stick? And so an applicant comes forward and they have an application that sets out all of the criteria they believe apply and they are to explain how their evidence shows that the criterion is met. That is their burden to show that, and that's what the application should provide. Then staff reviews that, and the staff report is those same criteria with that same analysis. Then we come to the public hearing, folks come to testify in opposition and they say this comprehensive plan policy says X. The evidence you presented says Y. You cannot approve this application because X says you have to show X, and they have shown you Y.
Yeah, because
And
X
that's
is not equal.
what compelling testimony looks like in terms of identifying what the criteria is and saying, that criterion says that you must do this. Staff has not done this. They have done something else. So there are sort of two components to your job. Your job is to interpret what the code says, the criteria itself. Adverse impact. What are those adverse impacts? How intense does an impact have to be adverse? What does the language of the code say about how adverse it has to be? That intensity question is always going to be a discretionary question that's going to fall on you. And it may vary depending on the circumstance. So you have an interpretation job, and then you have a fact finder job. And your fact finder job is, I have an application from a licensed traffic engineer. This licensed traffic engineer study has been reviewed by the city's licensed traffic engineer. It has been reviewed by ODOT, who has traffic engineer. I'm just making up. Sure. That is evidence, and you can decide whether that evidence is more reliable than lay testimony or not. But that is part of the evidentiary burden that you all have to bear. And then I think this question of, once staff knows, Laura and I know how you want to interpret the standard and which evidence you think is believable, it's our job to help you draft findings that are defensible. We'll provide you the analysis, but you have to be clear as the interpreter of the standards, which ones you believe apply, what they mean, and whether they're satisfied. And that, and Laura and I get paid the big bucks to make it all fit within the four corners of pieces of paper.
Yeah, the biggest problem we have is the layperson just kind of to a large extent isn't prepared to come up and say 17.6.4.3 is not being met because X, Y, and Z. They come up and say, traffic has gotten significantly worse and my dog's been hit twice because this other subdivision was built, and if you let another subdivision be built, then my kids are going to get hit. So we have to interpret that as being you don't accept the traffic report.
Well, I don't think that, I appreciate the challenge, but I would encourage you to ask these folks these questions.
Mm-hmm. I mean, there
Because
are.
because you know, my job is to write a defensible decision.
Mhm.
And that decision has to respond to all the testimony that's presented. And so I have to be able to I have to put things places. And I can't be sure I put it in the right place if it is the traffic out here is terrible.
Right.
Um,
Well, and that's why you see, especially Denise, hammering the professional testifiers that we have, because they know after 57 testimonies that they better be saying 7.4, 0.6, 0.3, as opposed to ick, which is, you know, the first person who's like doing this, you know, sitting and yeah, that's the hard part for both
there's
of
a
us.
spectrum. There's a spectrum, and there's also There's also, I think, there are applications that are big and contentious and time consuming, and those are where we need to be putting our attention on details. And there are ones that are not contentious. And I'm not suggesting that we're going to, you know, be grilling an empty room about adequate findings.
Yeah.
You know, there are places that money is better spent.
Yeah.
And you know, Oregon City has in recent years seen its fair share of large, contentious matters. And we need to, all of us, be careful and learn our lessons as we go. And you guys are all experienced planning commissioners. And I mean, one of the things that I think would help staff is being real clear about how you're interpreting the standards and asking testifiers to identify what is the standard that you are saying. And just providing a laundry list. Goal 7, Metro Code 4.6.8, Metro Code 4. Title 4. Just giving you a laundry list is not going to do it, right? I mean, if we're going to say to applicants, you need to do a better job of giving us the data, we need to put it on others too, that they need to get us the information too.
Well, the burden of proof is on the applicant, according to Fasano.
It is. But if somebody's going to challenge,
Go Beavers.
Did you give them your card in case they have any?
Go away, Beaver. Sorry.
it is on the applicant to show the criterion is met, but it's also, you know, an opponent cannot preserve an issue if they don't present it fully to allow the planning commission an opportunity to respond to that issue.
So we have the
They can't
right.
hide the ball.
Do we have the right to say prove it?
No, I don't think it's so much prove it. It's provide us what is the measuring stick. You don't have to prove it. You've provided a whole bunch of testimony out of expressing concerns about X. What criteria do you see allows us to consider X?
I've done that several times at meetings. I've asked them, you know, what is it? What's the point? So I think from now on, I'm going to bring a measuring stick with me to the meeting and put it there in the front so people can see it, because that's a good analogy. What I get a little concerned about while we're talking about deliberation and decision is that we have a community that is passionate about some things and not passionate about other things. And what I fear sometimes is that the process has gotten to the point to where it doesn't allow for an average person. And that's what I hear a lot, is that people say, well, I don't know what to do because I'm not a professional person. Well, I tell people you don't have to be a professional person. But it seems like with every court case we have, there's, you know, more rules and things that come up. And so how do we give the appearance that we're not expecting chapter and verse and that they don't have to be attorneys, but also help the public
Focus?
Yeah, I mean, part of it is because as a person who's been very proactive in terms of citizen involvement, I believe in giving people the benefit. I know that they're here, they've taken their time, they're coming up to talk to us, they might not hit on the topic, and I know, guys, it gets frustrating, but we have to give them some props for actually even showing up to be here.
Yeah.
If we can, in a kind way, help guide them, we're not trying to give them the answer, but help them, then I think that's part of what we need to do. We don't want people to say, well, I'm not coming here because I'm not an attorney. You know, I'm not coming here because I'm not a traffic engineer. I'm
you
not
won't
coming
listen to me.
because, yeah, when there's that too. So it's a fine line that we
Yeah.
straddle.
Yeah, because on the other part of that, I don't want to spend the entire night on one item spoon feeding folks either. You know,
No, I'm not saying we
especially
do
I
that.
think we got to
but
gauge
again,
the
it's what I
temperature
said,
antenna up
it's a
about
fine,
how
fine
big the room
line.
is
I had a
and how full it is. Yeah, you're
I had a
right.
thought while
That's
listening to
good.
all this, and
Yeah.
I know we have these charts on the walls over here. Is there any way for when we do hearings like this that we could have a cheat chart on the wall that we put up there during a meeting, say these are some of the criteria that we're going to be looking at, and if your testimony doesn't apply to
Is
this?
it on the slides? They do it
Why-
on the slides.
I know, but some people they're sitting out there anxious to testify. It's totally gone from their mind by the time they get up there to say what they want to
That's why it could
say.
stay up there.
I
It could
think
stay
copies of
there.
the staff report are available.
Yeah, that's a good
The
question.
staff report, but
So
I'm-
we list the criteria on the notice that we send out and post online and put in the paper and all the other ways in which we distribute it. And we also obviously include the criteria in the staff report. We do have a sheet on our website that guides people on how to provide effective public comment. We have been going to a lot of neighborhood associations and CIC and doing education about how to do that. So we're trying our best to educate the public. I think the other side of this is, listening to people, but then also when people provide comment, it's nice for them to know ahead of that about the criteria so that they don't feel like you totally ignored them when they don't talk about any criteria either. We want to set the people up for success who are providing comment. So, I mean, balancing that both ways, right? Making sure that they know what the criteria is.
But that's why I said maybe having a chart in here, because a lot of people don't go to the meetings in their neighborhoods. They don't know. They're just here because they're emotional or passionate. And maybe just a guideline that, like right up here,
Somebody told them
during the
to.
hearing, these are some of the criteria that we have to make a decision on.
We've done that, and so for most of the ones, you'll see one slide that says, here's the criteria, and it lists the chapters. But I don't know that that's really.
I'm
once
just
they're
saying
already
basics.
Here,
We could put it back up.
it's in the
I
staff
think it's
report.
better
all
just
over
to be
the place.
verbal about it and
Yeah.
just admonish folks at
They
the
won't
beginning,
listen.
at the preamble.
Hey, this is what we're going to be basing
that,
our decision on.
We're basing our decision on the criteria this evening, folks. You really need to attach your testimony to the relevant criteria before you. Otherwise, we're not going to be able to understand what you're talking about.
Yeah, yeah.
We have that little
Or we're
handout
not
sheet.
going to be able to use what you're talking
Or
about.
Yeah.
use.
No, we'll hear it.
Right.
But it's just like when Carrie was giving the example of, we've
17.1,
had some
but-
hearings where they came up and told us how wonderful the thing was and it was great and it was dandy, and I said, okay, that's really super. I'm glad.
Yeah.
How does that help me make a decision? You're not really talking about the criteria. And of course, I got the,
But we just spent 3 minutes listening to that and the meeting's going
this
on
was
to
a whole
midnight.
series of.
I know. I'm just saying
It was
that
a bunch.
that can go on
Yeah.
because some people have in their mind, my testimony is so important. I've got to get up there and say it, even though it doesn't apply.
I don't think she's not
No.
saying she's going to cut them off.
No,
Yeah.
no.
She's trying. Again, it's this.
I'm trying to
steer
direct
people
them.
to the right.
Yeah, it's not like, this is the greatest thing since sliced toast, so you really need to approve it. I think we get a lot of letters. Matter of fact, I'm thinking of some letters we got from our local business association. This is really great. You should approve it.
Mm-hmm.
Yes, thank you so much. I appreciate that, but that doesn't help me. That doesn't help me with anything.
Right.
Well, and one
It's
thing,
not a popularity contest, and I think we need to put that. This is not a popularity
We
contest.
have
Well,
other members of the city commission coming in to browbeat us.
Well, what about this? When you close the public hearing, couldn't our chair, Denise, advise people, this is what we'll be basing our decision on,
Yeah.
Yes, we
and
just talked
just
about
write all
that.
those down, just before we enter into discussion amongst us. We appreciate your testimony, as it's been widespread,
well,
different points of view.
that's why the last couple, like Charles and stuff, has said, can we go back to the criteria slide? And then
Yes.
it's like up there while we're
Yeah,
deliberating
and that's what
stuff. So
that's what I talked to Laura
Yeah.
about. Is that
Yeah.
once we get through the report, we could just put the criteria back up, and
Yes.
they have to look at it whether they want to or not.
Yeah, well,
and
that's-
it's sitting there.
But if you were to announce it to them, this is what we're going to be basing our decision on, just telegraph it to them.
Well, we do talk about that.
Yeah.
And I
It's
think
part
that's
of
more
the-
important at the beginning, so they're seeing right off the start that we're not saying after they've already gotten up there and poured their tears out to us that, oh, sorry, but that wasn't important, but we should say it right up front.
It is.
How
It's in
about
the it's in the
how
first
about
paragraph.
After you close the public testimony, I mean, you close the public hearing. Well, I'm sorry. No,
No,
Yeah.
I think we're just
The
getting
first
better and
paragraph
better,
talks about the
and we're
criteria.
focusing,
never
and,
mind.
Yeah.
and we have to
You gotta-
practice
you
it
can-
as well as.
Again, I'm not suggesting that you know grill every person
No.
who gets up here. I think you're
Gonna
gonna
grill
have
anybody.
to use some discretion and some judgment about whether or not this is worth
And that's
inquiring
why.
further.
And that's why.
But
I know.
there,
Yeah.
as testimony goes on, and we're in hour 2. Sometimes I feel, and the testimony often is very related. They're the same issues.
Yeah.
And I feel like sometimes, on testimony number 12,
Find a spokesperson.
what?
Yeah.
I mean, and it's not so much find a spokesperson and don't repeat, because I understand people want to have their say, and
Don't have
we're
their
talking
day.
about 3 minutes, so I have no problem with that. But my feeling is sort of, let's redirect this.
Yeah.
Well, I want to hear your testimony, but I'm trying to understand what the criteria is that you believe is going to get a different outcome.
Yeah.
Which one is it? A lot of the criteria are very related, and it would help me out tremendously if you could elicit from the public. We've heard a lot of testimony tonight about X. It would help me as we're moving, towards the end of this hearing this evening, if you all could direct your testimony to these criteria, to the criteria.
In 3 minutes.
And I'm not
They can take turns.
meaning to, when I'm sort of opining here, I'm not trying to discourage you all from putting your own
Yeah.
words, but again, kind of keep that in mind as these hearings go on, because I think it would help everybody. Again, the goal is to narrow, so we can get to a decision.
Yeah, and I was just going to say, one of the things I try to do is, if that person who did the my dog and whatever, rather than because that's clearly somebody, you ask them a question and they're done. Is to make sure that when I'm deliberating, if what they said is affecting me, that I say, Mr. Smith's testimony about his dogs really makes me concerned about traffic, so that you guys can say, that testimony, they're taking it as a traffic statement testimony, so that you're not trying to figure out what was going through my head and what synthesis I took out, that there was this testimony about this thing had an
Well,
impact.
and I think that's an important part about the deliberation process. And it's always one of the great things that you all do is you poll everybody, and so everybody has their input, and others' input helps influence your decision. But again, the more detail you give us about what evidence is important, how you interpret the factors or the criteria or the standards or the goals or whatever label you want to
Right.
put on it, the ones that are really important to you, or that are compelling to making a decision, that's what we have to write a decision about.
Yeah.
And the more material you give us, the better.
The one shame about this evening is, and I know this is like a scintillating topic for many people, but that we have one neighborhood person here who knows some of this stuff and is here to get more information, and it would have been just awesome if more CIC people had been here. Not that you're not going to give this in front of them, but it's different when they hear us talking about it and how we are going to go about
Yeah.
trying to make a
Provides context.
decision that yes, thank you, it provides more context. Bob,
I do have a couple questions.
come on up.
You know the rules.
We'll send it to the CIC, a link to the video.
They're watching it.
It'll be well under
They're
3
watching
minutes.
it live.
We could do
Hi, Charles. Hope you're watching this.
Type
He's
3
done with
review,
it.
can that be put before both the planning commission and the historic review board?
What?
No, I think the answer is
One or
no,
the
but
other.
Laura ought to answer that.
So type 3. So is there? Okay. So we have applications
reviews.
that include sometimes multiple hearing bodies. For example, making this up, if there is a individually designated historic home and they need a conditional use permit or something like that.
Because they want to convert it to a lawyer's office or something.
Yeah, or they want to build a new church in McLaughlin. I mean, whatever the thing is. So you have to go through multiple places. You have to go to the Planning Commission. You also have to go to the Historic Review Board. You need both of those to be approved in order to construct things. And
Abernathy Chapel is an excellent example.
yeah,
Came to Planning Commission and went to Historic Review.
the applicant can choose which order in which they want to do that. But the two boards, they're both type 3 and they're totally separate processes, unattached from each other. Historic Review Board has their criteria and they're very specific. Planning Commission is the same. You'll see some of these processes a lot when it comes to historic things where there's geologic hazards or some type of stream or slope protection. They might have multiple processes that they go through. So essentially, yes, there's 2 type 3 processes that can exist, Planning Commission or Historic Review Board.
But a historic review board decision will never get appealed to the planning commission.
Right.
A historic review board decision gets appealed to the city commission.
Yeah, they do this. It's,
So each one of those individually has their own 120-day timeline?
Correct. So Planning Commission will never look at any Historic Review Board criteria ever. And yes, they have their own separate processes and their own timelines.
to be correct, we might, but only because those criteria overlap.
Yes.
Not because it's a historic review board criteria, but because building height is in both of our criteria. I'm just picking something as a,
Yeah.
you know,
Could be that.
You'll look in
or-
your criteria if theirs happens to
yeah.
overlap.
Or
then
site
they'll
plan
look
and
at it.
design review that could take place where it could affect it. I don't know. Could
Yeah.
be.
My second question is, if the planning commission made a decision and it goes forward to the city commission, does another 120-day time frame come into effect with the city commission?
No.
It's all the same
There's
And-
only
and
one
from the-
120-day period.
from the date of application.
No, it's from the date of completeness.
Yeah.
When the staff and the applicant, depending on circumstances, deem an application complete, that's when the 120-day clock starts. And all the decisions have to be made within that 120-day period.
Yeah. And
Normally, most of our decisions don't go on to the city commission. So the 120 days would be in this arena. But then you have to count in, let's say it could be appealed,
yeah.
and that has to be within the 120 days.
Yeah.
Well, and
Which can be very
Days.
challenging for
Can be
staff.
very challenging.
Yeah.
Right? I mean, as something that has to go to Planning Commission, then City Commission, and we have continuances, and we have to get a final city decision. Or even if it's Planning Commission plus an appeal to
It's
Planning
tight.
Commission, it is tight.
It's tight.
Yeah, and that's what I was when I was referring to, like the city commission referring things back, because I remember being on the city commission and getting a couple of appeals up, and I know one we sent back because there was like crazy amount of time on the clock, and another one it was like we need to send this back down, and can't remember who was the director at the time. It was Dan at Trentlaw, I think, at the time, said, we've got like
3 days.
12 days. You know, we might be able to type up our decision. You need to make a, up or down. And so that's where we considered new evidence and said, because of the clock, we're going to make a decision that, but, that's where, that could possibly pop up. But yeah, the first one was just like, oh, that's new evidence. Send it back and let them reopen the.
Good questions.
Okay, that's all I had. Thank
Yeah.
you.
It is hard,
Thanks, Bob.
especially when you make your decision. Then you wait 2 weeks to see if you even got an appeal.
Yeah.
And then you have to write a report on the appeal in 3
And
days
then you have to
before
give notice.
you.
It's rough. Sometimes you have to get a notice out in advance,
Yep.
in anticipation of
Yeah.
possible appeal. We've done that before in our
workshop.
We have done that too.
Yeah.
Yeah, sometimes I wish the clock would allow, when we get a staff report that's like in excess of 50 pages, it's just hard to go through. I mean, we have 7 days, you know, that is tough to get through.
Yeah.
We've been trying, our goal has been to send it out the Friday before, so you get 2 weekends rather than the 1 weekend, but it can be challenging. I mean, our staff this year has been, I mean, it was Pete and I was doing another job most of the time at the very beginning of the year, and
Well, and I have to say, both you, Carrie, and you, Laura, and Pete, it's, like I said last meeting, the way you've been able to adjust to us for, like, let's rearrange how I just blanked, the exceptions at the end of the thing.
conditions of approval.
Conditions of approval, like how they're formatted, so that, you know, they're, and also how you've trained us to say, please be more specific, or, yeah, and I appreciate the fact that you just say, I don't understand what you guys are asking us to do, you know, because I remember being, you know, back on city commission and stuff where it's like, okay, and then, you know, it would be like, oh, you could just see the oh my God, what am I going to do in their eyes, and I would much rather have that conversation, 2 minutes, you know, of what did you mean, rather than just the, you know, the chaos. I mean, I've been kind of on the other side of where I've received the, now what am I going to do? And it wastes so much time. So, you know, by all means, get us back on track, and by all means, let us give you the, you know, the proper track. And I like the fact that we are a team, as opposed to we are the edict and you will march to our, no, that is not anything I will ever be part of, or I will try to tear it down if I am part of it. So
Well, let me add one final thought, is that it really, I'm not picking on anybody at all, I'm just making a general statement, it really helps the staff if we look over the reports. Even if you don't want to read it verbatim, looking at it really, really helps, because they are assuming we are reading it. So let's not assume, let's read them. That way we understand where they're coming from, we can ask our questions, we can be very specific with a lot of specificity, quoting Ed, about what we're trying to understand. And it just makes all the difference in the world. And believe me, sometimes I burn the midnight oil and I'm reading them, and I'm reading the same thing over 5 times thinking, okay, time to go to bed now. Can't read that anymore.
One thing that we might start recommending more as staff is if there's, you know, a request to add another condition of approval, we might start requesting for a 5-minute break so we can craft it and then come back.
Mm-hmm.
Sometimes it's a little hard for us to be writing and trying to read that writing.
Yeah, we don't want you to write them on the
during
spot.
that, so
That's
we may,
done. We're done with that.
you might see that a little bit more.
well, and that also allows you to meet with the applicant to see if your language, if they're like, if they have any issues, so they're not up here testifying that we don't like the way that was written and it should be may instead of might, and you know, because that wastes people's time too. And so, yeah, I would never have a problem with taking time to do it right.
I'm not concerned whether the applicant likes the way we've written it. That's going to be our decision.
I'm talking about them wasting time talking about it.
We've closed the public hearing. They're not coming back up here to ask us anything more. That's it.
Well,
We're trying to make a finding, and they can't come back and now then challenge that finding and tell us, I don't like the way you said that. They can talk to the city.
no, it becomes an appeal, and then it's a waste of time.
Well, it's not a waste of time. They don't have to agree.
I'm just saying, 2 minutes with staff
It's
out in
some
the
of the
hall
small
is
things,
infinitely
yeah.
better than wasting
I don't
people's
want
time.
us to get into the thing where the staff is out there and we've got the public saying, "Oh, what are they? You know, what are they talking about? What's going on there?" I don't want to give that appearance or the perception.
I've seen that perception by.
We'll take care of it. I mean, the point
Yeah.
is so that we can talk to the lawyers and make sure that everything is, we all heard what you're saying, and crafting a condition.
Yeah, because I'd say 99% of the time you've done that,
But if the
you
public
and you've
doesn't like
said
the way we
something,
word
and the person, you know, the applicant in the audience is nodding, like, yeah, okay, you know, which they're not testifying, but it also means, okay, that's a, you know.
Yep.
it's hard because we have the lawyer over there and I'm over there
Yeah.
and the planner's over here and we're trying to like
And you're both taking
signal
notes
to each other
yeah.
and
Get a
just to
little
connect a
whiteboards
little.
maybe.
Yeah,
Yeah.
You guys should all be sitting.
Yeah. So
we'll
no,
just hold
that's-
up different letters.
like I said, I'd much rather you take a few minutes to get it right
Yeah.
than guess wrong.
Thank you.
Right. Yeah.
All right, gentlemen, anything else? As you can tell, I would like to get the meeting done with. I'd like to be home before 9 o'clock.
Because you want to see The Bachelor.
I don't watch
Just
The
want to see
Bachelor.
which rows. Go ahead, whack it.
Anything else, guys?
For me.
Okay,
No communications.
Yeah.
we are